Good morning. May it please the court. My name is Tom Saunders and I represent Florida Home Design. The matter below arose as a result of an initial contention by Florida Home Design against the Homeowners Association relative to some records dispute. During the course of that underlying litigation, Florida Home Design sold the property and thus the trial court originally dismissed that action based on mootness. The Morgan Creek then moved for attorney's fees in a timely manner, filed that motion in May of 2011. In July of 2012, they set that motion for hearing on the issue of entitlement only. The court granted an order finding that they were entitled to attorney's fees, and a noticed evidentiary hearing was set for September of 2012. That noticed evidentiary hearing was noticed 2 months in advance. At that hearing, Morgan Creek presented the testimony of its Homeowners Association president. It presented the testimony of its then attorney, Robert Stans, and it presented the testimony of an expert attorney, an attorney fee expert. At the conclusion of that evidence, the trial court found that Morgan Creek had not carried its burden of proof and dismissed or entered an oral order finding that we were entitled to an involuntary dismissal because they had not proven their damages. New counsel substituted in for Morgan Creek and filed a motion under 1.530 seeking a rehearing and reconsideration, arguing that they should be entitled to place additional evidence into this record to essentially retry the case. Mr. Miller, who was then new counsel for Morgan Creek, admits in this record that what he seeks to do in the rehearing is put on all new evidence, put on the evidence of the multiplicity of law firms that were involved in this matter prior to the entitlement award of attorney's fees, again call experts. It is our position that the established case law of Florida, including this court cited in our brief, is that when a rehearing is granted solely because there has been a failure of proof below, that such a rehearing is improper, that it falls within the second bite of the Apple case law that says if you have had an opportunity for an evidentiary hearing and you have merely failed to put on the necessary quantum of proof, that the motion for rehearing is improper.
Do you have a case that holds that in a situation where it's not a cause of action but a claim for fees?
I have no case that addresses that specific point, but I do think that several cases read together answer that question. I believe that the Roganman versus Boston Safe Company does away with the distinction that's been raised in the answer brief between an action for damages and an action for attorney's fees. Roganman establishes...
This isn't an action for fees. This is a statutory claim for fees as a result of an action. And in terms of, this is not a cause of action.
I certainly agree with that.
It's not an element of damage within a cause of action.
I certainly agree with that. The quantum of proof, however, and this is what I believe Roganman says, the quantum of proof necessary to liquidate a claim for attorney's fees, be it ancillary or part of the main claim for damages, requires the same evidentiary proof that any other matter to liquidate a claim would require. And that if you're given fair opportunity to do that, and you are unable to do that for whatever reason, simply saying, I didn't do it the first time correctly, I'd like to come back and do this again, is not favored by the courts in this state. When you combine that with the decision of this court in St. Pete Housing versus JR, the quotation by this court was that the law presumes that at the conclusion of the trial on the merits, people have presented all the evidence that they need, and that a rehearing is not to present evidence that was available at trial. Clearly, this record does not speak of anything other than every bit of things needed to present this claim below during the noticed hearing was available to the then attorney prosecuting this case. Maybe even available with the witnesses that he had there.
I'm curious, the fees that were stipulated in the end to allow for this appeal, how do they compare to the invoices to which you objected?
Approximately $8,500 less than that which they were seeking, irrespective of costs. There was the original matter, we did stipulate that certain costs had been adequately proven. We simply think that it is a bad precedent to allow another bite at an apple when it is something other than merely placing in, as we put in our moving papers, merely placing in a note, or merely placing in an insurance policy, or some other piece of relatively innocuous evidence that was inadvertently kept out of the record. But here, that's not what's being requested. What's being requested is essentially a new trial, be it on an unliquidated claim for attorney's fees or damages, such as a bad precedent. We would request a few minutes of rebuttal.
Okay, thank you.
Good morning, and may it please the court. My name is Christy Hatcher-Bolin. I'm here on behalf of the Appellees, which are Morgan Creek Property Owners Association and Landstar Lakeland. We're asking this court to affirm the stipulated final judgment, and in doing so, we would request that this court bear in mind the procedural posture of this case, which is very different from the procedural posture and the nature of the matters that were addressed in a lot of the cases that the appellants rely upon. First of all, by the time that a request for continuance of the evidentiary hearing was made, and at the time that the rehearing, motion for rehearing was filed, you had a summary judgment disposing of all of the claims on the merits. The underlying claims had been disposed of. Nothing needs to be retried, redone as to the actual claims. You had also an order finding that the appellees were entitled under Chapter 720 to attorney's fees under that statute as the prevailing party, again, not as an element of damages, but as a prevailing party under that statute. You also had where the appellee's prior counsel had put into, they actually filed with the court, a notice of intent to rely upon affidavits in lieu of objection by plaintiff, in lieu of live testimony absent the objection of plaintiff. We don't have, I don't know what's not a record, but as far as the record is concerned, we don't have any, and I'm not saying it's absolutely necessary, but I'm saying they were on notice. They were on notice nearly a month before they had this evidentiary hearing that he wanted to rely upon.
What's difficult about this case is what's necessary to prove attorney's fees in a hearing is not novel, it's not tricky, it's not hidden in the case law. It's about the most straight up thing that's out there. And what the suggestion is to allow somebody to put on a case, not bring forward adequate proof, lose on the issue, and then be told, well, this is why you lost. Okay, well, we'd like another hearing now so we can get it right this time. And there's just something about that that's difficult. And of course, if we adopted that in everything that we do in the trial courts, you talk about delay in the trial courts, we'd be doing everything at least twice. Every time somebody didn't get the ruling they liked, they'd say, well, gee, I didn't know. You know, well, lawyers are supposed to know, and so we just start all over again now that they've been told what it is they should have done the first time. You see what I mean? It's a hard sell, you know?
I do understand, but I think that's also similar to, you know, improving a claim for breach of contract. You got to actually put the contract into evidence, or you have to put the insurance policy into evidence. And those are the same type of cases, such as Amador, where, you know, there's
more than ministerial. I mean, you want to bring in new witness, up the ante on the proof. Is there any case that allows this?
I don't know.
Do you have any cases that support what you're asking us to do?
Do you have any cases that, I have all the, basically all the cases that where they inadvertently failed to put in something, and I do want to.
Anything about fee, where there was a fee motion that was not sufficiently proven and the party came back? There's nothing like that.
We're dealing with basically an imperfect case, yes, and I don't have anything that clearly lines up to that, but
Let me go back to your prior predecessors. They filed this notice of intention to use routine, which, and how long was that before the hearing?
That was about not quite a month. I believe it was filed on August 17th. The hearing was on September 12th.
And there's neither a stipulation that this will be okay or a filed objection that it won't.
Correct. There's nothing there. We don't have an objection in the record until we actually get to the hearing.
Is there anything in the record that would suggest that the attorneys on your side of the case were surprised when they went to the evidentiary hearing that they didn't have an understanding about this?
It's not in the record, and at that time, Mr. Stans, not Gray Robinson, was still representing the appellees. So, and like I said, I don't know what happened, but that's not in the record. We don't have, and you're correct, we have neither a stipulation nor do we have an objection. So to get to the hearing, and as soon as it becomes a problem, he asks for a continuance. He asks for a continuance, Mr. Stans does. Basically what they need, and it's not, these documents, these records were already admitted for the limited purpose of basically establishing that, sure, these people hired law firms, they received bills, and they paid the bills. Now, and basically what happened is they didn't have someone come in and testify, well, this was the work that was actually done. The records, though, are still before the court. We're not talking about an inordinate, we're not talking about a 5-day trial. We're not even talking about a 1-day hearing. We're talking about pretty much a short hearing just to establish that this was the work that was done so that the court could therefore then apply the row factors in deciding what a reasonable fee was. The cases that they rely upon are pretty different procedurally and as far as the actual stance of the case, what they were trying to prove. For example, in St. Pete versus JR Development, which was just mentioned, as well as I think it's Allard versus Al Nayem, those cases concern the merits of the plaintiff's substantive claims, whether they actually proved damages under a correct theory, and whether they were entitled to relief. Damages are an essential element of a claim for breach of contract. Here we're talking about an ancillary fee motion after all the substantive claims have been dismissed and after a finding, after an order that was entered, finding that they were entitled to fees. Second, in both of those cases, St. Pete and Allard, I would also add the St. Joe Paper Company versus Connell, the plaintiff failed to present actually a viable theory of damages. It wasn't merely you failed to put in a document, you failed to put in a witness who could testify that these are business records. And that specifically was what we were dealing with here. Somebody who could actually testify that those were business records, the exception to the hearsay rule.
What was your expert ultimately allowed to say in this case?
I'm sorry, I couldn't hear you.
At the hearing, I know you had a fee expert. Was there actual testimony as to an opinion that got into evidence?
Yes, he did find that overall that the fees requested were reasonable. He did make some deductions, but he did testify as to an opinion that they were overall reasonable. He did not go through, however, I think each individual timekeeper's time records, and that's why we needed someone to come in to basically say, well, this is the work that we did, to get it in under the business records exception. And that was the actual objection that was raised during the hearing, was the business records exception. That it was hearsay and they didn't have anybody who could testify that they were business records. So that's what we were dealing with here at the time of the trial. Excuse me, at the time of the evidentiary hearing, I'm sorry, is that we had an entitlement. It was an ancillary matter. We simply needed to bring someone in who could get these in as business records. The requested fees, unlike so many other cases that they've cited in their papers, were not an element of damages. And this court and many others have held that in general, attorney's fees, unless it's actually defined as damages in a contract or a statute, that attorney's fees are not damages. It's an ancillary matter. And as a matter of fact, with the prevailing party fee provision, or here a statutory provision for prevailing party fees, you can't even determine whether or not someone's entitled to fees until there's a determination of prevailing party. And we had that in this case. We had a finding of entitlement. Going back to the hearing, I know the question, Mr. Stans, he didn't want to rest, basically. He wanted to continue to call in the attorneys to testify as to those business records. Not only did he timely make that request for a continuance before the end of that hearing, they filed a motion for rehearing before an order was ever entered. We're not talking about vacating a final judgment. We're not talking about redoing everything. We're talking about simply bringing attorneys in basically so they can get these records under the business records exception. That indicates that it's an abuse of discretion standard where he actually timely requested to continue the hearing. It might not have been in form a motion to reopen. As a matter of fact, that really at the time he asked.
Was the motion to continue denied?
The motion to continue was denied.
And is that an issue on appeal here?
Well, I'm ultimately, and I know the issue has been raised as a cross appeal, there was no order for us to cross appeal. What happened is that he made the request for continuance of the hearing. The court denied it. They filed a motion for rehearing prior to the entry of any order on attorney's fees. That motion for rehearing brought up a few things, and among them was the denial of the continuance. And basically the appellee said that, look, we asked for continuance. We just want to bring someone in to get these business records in, and you abused your discretion when you denied us that continuance. It also asked that basically the court, even though the evidence had actually not closed, you never rested, that you reopen the evidence so that we could bring in, again, the same thing, bring in an attorney to testify as to these business records. All of that was done prior to an order ever being entered. And then basically what happened, I guess to kind of clear up his ruling, is that when Judge Self entered the order granting the motion for rehearing, he attached an order on the attorney's fees that he said was deemed entered and vacated. So that was done at the same time. But at the time that they moved for rehearing, at the time they heard the motion for rehearing, there was no actual order entered. We think that the trial court's exercise of discretion was absolutely proper here. We're not talking about a final judgment being entered. The request was made timely. The character of the evidence that they sought to present was simply bringing some attorneys in so that we could get these records in under the business exception. We're not talking about a full-blown trial, not even an extensive hearing. Because again, those records were already in for the limited purpose of showing that these fees had been generated, they had been sent to the appellees, and the appellees had paid those fees. And that was already before the court. That was actually an evidence. That was the testimony here. And that would be the effect of basically allowing the rehearing to go forward, is that you would just bring in those attorneys. With respect to the reasonableness of the request, again, I understand this is not perfect. They did have those records before the court. When the objection was raised, when the trial court expressed some concerns, immediately Mr. Stan said, well, let us go ahead and continue this, and we'll get those attorneys in. It won't be a problem, and we can do that. It was denied. When the rehearing was heard, actually, Judge Self said that, he recognized that in substance that Mr. Stans was asking for an opportunity to reopen or continue the hearing and not to rest during the hearing to determine the amount of fees awardable. And after denying that request, the trial court did not err in subsequently granting rehearing, and for that reason we respectfully request that you affirm the stipulated final judgment.
You have a motion for fees under 72305, and that's the statute from below, but is it equally applicable to an appeal of these issues in this court?
We believe so, because again, they are challenging the propriety of allowing these fees to go forward. I will tell you though, there has been no actual challenge to entitlement. This is simply a challenge to granting rehearing to allow them to present their attorneys who would testify as to those fees and get those records in as a business records exception.
I think you filed a motion here for fees.
Correct.
And my question is, does that statute entitle you to appellate fees?
I believe so, yes. There's not a whole lot of case law on it, but we're asking the court for fees under that same statute. Okay. As the prevailing, if in the event we prevail. And
yes,
again,
I understand that part.
Thank you for your time. Thank you for your time.
Okay. Mr. Saunders?
Your Honor, a few small points, starting first with the affidavit. I do not dispute that counsel a month before advised me that he intended to potentially use affidavits absent some objection. When he tried to put the affidavits in through a particular witness, I objected. But sitting there was his attorney fee expert. And the point I wish to make is that this evidentiary hearing, as counsel candidly admits, all these records that were needed to prove the attorney's fees were sitting in front of that expert. The affidavit was there. All of the bills were there. What we have is a situation where the expert did not do his job appropriately through testifying to do what was necessary for the trial court to award fees under Roe. To come back now and say that we moved immediately for a continuance when the hearsay affidavit was first objected to, I do not think is consistent with the record. I believe Mr. Stans moved for a continuance only when we were arguing on my motion for involuntary dismissal. I believe we need to stand on this court's decisions and the other court's decisions that do not countenance this second bite at the apple. It is by no means something that I relish, but the fact of the matter is the matter wasn't proved there, and we're not seeking to put in merely a piece of paper. We're seeking to redo the trial. Where would we draw that line? Thank you.
Thank you. Court's going to take about a 10-minute break. When we come back, we'll take up the last case, which is Bergerman versus Appellee.
I was just wondering, did I hear yesterday?